Not everyone reacts rationally when they feel wronged, especially when their landlord decides they're no longer welcome, suddenly evicts them and changes the locks. But what does the law say about this? Is your landlord justified simply because they own the property? In this week's edition of Query This, Chantae McNeil breaks down the law governing evictions in Jamaica.
Query this. You have a disagreement with your landlord. Maybe it's about late rent, repairs, or even a personal issue. Then you leave for work only to return home to find your belongings outside and the locks changed. How would you react? Was the move legal?
I'll call the police and I have to do something about it. You can't just put me out, sir.
That's illegal, first of all, to break a lease. And then that's just unethical because it was done all of a sudden without any prior notice or anything like that. So yeah, I don't believe that's right.
But I just find the next place to live, you know. I can't find a jailhouse thing that.
I think there's a better way of going about it, but they have the right to can do that still. I think so.
Well, not quite. Under Jamaica's Rent Restriction Act, landlords who forcibly remove a tenant without due process can find themselves in legal trouble. Attorney-at-law Michaelia Green, who has handled several of these cases, explains the right way to go about an eviction.
A landlord is not permitted to remove any personal belongings or any sort of property, chattel, in the possession of the tenant during his or her tenancy. What the landlord could do in order to get some possible recourse is to serve what is called a notice to quit in order for that tenant to deliver up possession within a certain period of time, usually 30 days. I handled a case recently pertaining to those exact facts, and the landlord got himself into some serious hot water. So the landlord found himself in a situation where he had to compensate the tenant, yes, compensate the tenant for any loss or damage done to the tenant's personal belongings.
A valid reason must be given. A formal written notice must be served, allowing the tenant sufficient time to vacate. If the tenant refuses to leave or damages the property, legal action must be taken. And for tenants who have been wrongfully evicted, especially if their belongings were damaged, here's your legal recourse.
Take out a plaint or a claim for the damage and loss to their items. Gather all their receipts so that they can buttress their claim in court to show that this is the value of the items, or if you cannot find the receipt, because to be honest, many of us don't remember where we put certain receipts, to simply have a similar item of similar value exhibited in their affidavit to support their claim against the landlord in court.
Landlords, there's a right and a wrong way to resolve disputes with tenants. Acting outside the law can have serious consequences. That's why I'm here each week, keeping you informed about the laws that affect you and answering your legal questions. If you have a legal dilemma, email me at cmcneil@cvmtv.com and I'll help you navigate the law. Until next time, I'm Chantae McNeil.